Chapter 3, Eligibility and the Application Process. How to get a pardon in Canada. To apply for a pardon or record suspension in Canada, you need to make an application to the Parole Board of Canada. The Parole Board of Canada is the only government agency in Canada that is responsible for ordering a pardon or record suspension. You need to complete the Parole Board of Canada application in full and pay the $50 processing fee. The pardon and record suspension application will require you to submit additional documentation, fingerprints, criminal records, court documents, and police checks. You are responsible for paying the fees for these additional documents. How to get a pardon in Ontario. To get a pardon in Ontario for an offense for which you have been convicted, you need to apply to the Parole Board of Canada. The rules to get a pardon or record suspension are federal, regardless of where you live or where the offense took place. Even if you live in Ontario or were convicted in Ontario, you must apply to the Parole Board of Canada to get a pardon or record suspension. Pardon in Canada eligibility. When can I get a pardon or record suspension in Canada? The eligibility rules that apply to your application for a pardon or record suspension are defined in the Criminal Records Act. First, in order to become eligible, you need to complete all your sentence in full. Completing your sentence in full means you have served all sentences of imprisonment, probation orders, and paid in full all fines, costs, surcharges, compensation orders, and or paid restitution. Second, in order to become eligible, you need to wait a minimum period of time. The waiting period only starts after you pay your fines, costs, surcharges, compensation orders, or restitution. So make sure you pay in full as soon as possible. The waiting period depends on when you committed your first offense, the offense you were charged with, and if it was a hybrid offense, whether the Crown prosecuted your charge by indictment or summary conviction. A conviction for simple possession of cannabis does not require you to wait. You can apply for a cannabis record suspension. If you committed your first offense before June 29th, 2010, the waiting period is 5 years for an offense prosecuted by indictment, 3 years for an offense preceded by way of summary conviction. If you committed your first offense between June 29, 2010 and March 12, 2012, the waiting period is 10 years for criminal offenses involving serious personal injury in accordance with Section 752 of the Criminal Code, including manslaughter that carried a prison term of at least 2 years, or an offense referred to in Schedule 1 of the Criminal Records Act, which is a sexual offense that involved a child that was prosecuted by indictment. 5 years for any other offense prosecuted by indictment, and an offense referred to in Schedule 1 of the Criminal Records Act, which is a sexual offense that involved a child that proceeded by way of summary conviction. 3 years for an offense not included in the above list that was prosecuted by way of summary conviction. If you committed your first offense on or after March 13, 2012, the waiting period is 10 years for an offense prosecuted by indictment, 5 years for an offense preceded by way of summary conviction. You are ineligible for a pardon or record suspension if you were convicted of an offense covered in Schedule 1 of the Criminal Records Act, which is a sexual offense that involved a child, or if you've been convicted of more than 3 offenses that were prosecuted by indictment, each with a sentence of 2 years or more. You were ineligible for a pardon or record suspension if you were convicted of more than 3 crimes that were prosecuted by indictment, each of which had a sentence of 2 years or more. What crimes cannot be pardoned in Canada? If you committed your first offense on or after March 13, 2012, you are not eligible for a pardon or record suspension in the following circumstances. You are not eligible for a pardon or record suspension if you are convicted of an offense covered in Schedule 1 of the Criminal Records Act, which is an offense that it involved a child. Or if you've been convicted of more than 3 offenses that were prosecuted by indictment, each of which had a sentence of 2 years or more. You are not eligible for a pardon or record suspension if you are convicted of more than 3 crimes that were prosecuted by indictment, each of which had a sentence of 2 years or more. When am I eligible for a pardon or record suspension in Canada if I was convicted of possession of cannabis or pot? You are eligible now for a pardon or record suspension if you were convicted of simple possession of cannabis. Simple possession of cannabis means you possess 30 grams or less of cannabis for personal use. You would not need a record suspension or pardon if you were charged but not convicted of simple possession of cannabis. You need to get a file destruction to completely erase your cannabis charge. If the Parole Board of Canada denies or rejects my application for pardon or record suspension, what happens next? The next steps you take in your pardon or record suspension application are determined by whether your request was rejected or denied. When you apply for a pardon or record suspension, the Parole Board of Canada reviews your application to review that it is complete and that you are eligible. If your application is complete and you are eligible, your application will be accepted for processing. If your pardon or record suspension application is rejected, means either that your application was incomplete or the eligibility waiting period was not completed. If your application was not complete, you need to complete the missing parts and resubmit your application. If your eligibility period was not complete, you need to reapply after you complete the waiting period. If your application is denied, it means that your application was accepted for processing, but that the Parole Board of Canada has decided not to order your pardon or record suspension. In the vast majority of cases, the Parole Board of Canada rejects your application because it discovers something about you that suggests good conduct is questionable, such as involvement in criminal activity after applying. Before your pardon or record suspension application is denied, you're going to get a letter from the Parole Board of Canada stating that they intend to deny your application. The letter will give details of why they intend to deny your application. The Parole Board of Canada will allow you to respond. Normally you have 60 days to reply, giving you the chance to explain why you believe they are wrong and why you should get a pardon or record suspension. If the Parole Board of Canada finally decides that they're going to deny your application, you will have to wait at least 1 year before applying again. Will the police come to my home or work if I apply for a pardon or record suspension in Canada? No. Communication with the police and other government agencies will be done electronically or through the mail. In some cases, you may have to go to the police station to pick up your local police record check. If I have an urgent situation, can I get my pardon or record suspension in Canada sooner or processed more quickly? No. The Parole Board of Canada treats all applications for pardons and record suspensions the same. The Parole Board of Canada understands that people have urgent situations regarding the impact of their criminal record, but it has a strict policy regarding processing time. All applications are treated the same, and processing time begins as soon as they are received and accepted for processing. How long does it take to get a Canadian pardon? Getting a pardon or record suspension in Canada has 2 stages: the preparation stage and the processing stage. First, the preparation stage takes anywhere from 3 to 12 months. The preparation stage covers the time it takes to get all the documentation required to apply for a pardon or record suspension. This documentation includes getting your fingerprints, court records, and a local police record check. Second, the processing stage takes anywhere from 6 to 12 months. The processing stage refers to the time your pardon or record suspension application is complete and you were deemed eligible. If you are seeking a pardon or record suspension for an offense that was tried summarily, then your application will be processed within 6 months. If you are seeking a pardon or record suspension for a charge that was convicted as an indictable offense, then your application will be processed within 12 months. If the Parole Board of Canada intends to refuse your pardon or record suspension application, then it may take up to 24 months to process your application. The extended timeline allows you to make your case for why you should get a pardon or record suspension. To get your pardon or record suspension fast, it is highly recommended that you start preparing the documentation at least 1 year before you are eligible to get a pardon or record suspension. How much does a pardon cost in Canada? The Parole Board of Canada will charge you a $50 fee for a pardon or record suspension application. You will need to pay additional fees to get your fingerprints, criminal records, court documents, and a local police record check. I am not yet eligible. Are there benefits to starting my pardon or record suspension application early? Yes. To get your pardon or record suspension fast, you should start your documentation preparation before you are eligible. Document preparation takes months, and incomplete applications or applications with mistakes will delay your pardon. Starting early has significant benefits. We can spot mistakes or missing gaps in information. We will work with you to fix these problems, saving you significant time. We can accurately determine your eligibility date. We can tell you for sure if you need a pardon. If you are not convicted, you need a file destruction, which has a different and faster application process. Our law firm, Next Law Professional Corporation, will prepare a reference letter stating that your pardon or record suspension application has started and will be successfully completed. Our law firm reference letter can be used for your employer, volunteer work, and immigration purposes. And finally, we will make sure that your application is submitted at the earliest eligible date possible. Do I need to hire a lawyer or law firm to get my pardon or record suspension in Canada? No, you do not need a lawyer to get a pardon or record suspension in Canada. All the documentation you need, including instructions, can be found on the Parole Board of Canada website. While you do not need a lawyer, clients hire us to improve their chances of getting a pardon or record suspension. Every year, the Parole Board of Canada rejects a significant percentage of pardon applications because of ineligibility and other mistakes. The pardon or record suspension application process is lengthy, challenging, and time-consuming. Our law firm takes over your pardon application process, improving your chances of getting a pardon or record suspension fast.